Welcome once again to another program of Issues in the News, where we discuss the important events that would have taken place in Guyana over the past week or so. And as is the norm, we have a packed agenda of issues to discuss tonight. As is the norm also, I want to begin by welcoming our viewers who are joining us on television from West Coast Berbice, Region number 5, welcome to another program of Issues in the News. To our viewers who are joining us also on television across the Berbice River, from Region number 6 at the east bank of the Berbice River, New Amsterdam, Kanji, and along the Quarantine Coast, all the way up the Quarantine River to Siparuta. Good evening and welcome to another program of Issues in the News. To our listeners and viewers who are joining us on Freedom Radio from Robb Street, Georgetown, welcome to another program of Issues in the News. And last but perhaps most importantly, to all of you across the length and breadth of Guyana who are joining us on Facebook Live across the Caribbean, North America, Europe, Asia, and all the way across the Pacific Ocean, down to Australia, New Zealand. Welcome to another program of Issues in the News. And I see many of you have already joined Jamil Azir, Cyril Raghubir, Zalina Khan, Govind Singh, Jack Jagdev, Suresh Ramatar, Wilbur Stevenson, and so many of you who are on. Press the share button on your phone. Share this program so that all your friends and all your followers can join us in tonight's discussion. I repeat, please share this program wide and far so that we can have the widest possible audience joining us in tonight's discussion. Use the comment section as well to indicate to me what questions you wish me to address, what issues you wish me to speak on, and I'll try my best to interact with you and to engage you. As I said, I would like this program to be conversational and interactive. So please, let us have a discussion and don't let me be speaking all the time. Again, share the program. Share the program from your phone, from your computer, from your iPad, or whatever device you're using to view the program on so that we can have the widest possible audience. I want to begin by saluting Queen's College on its commemoration activities as it celebrates 180 years in existence. I am a proud alumni of Queen's College, and I want to take this opportunity to wish all my fellow alumni all the best. We come from a great academic institution. We are part of a great academic tradition, and I am proud of the activities that have been launched this week in celebration of the 180th anniversary of that prestigious and majestic institution called Queen's College. I want to specifically congratulate the Old Student Association of that great school for the magnificent job that they have done over the years, but more particularly in organizing a packed agenda of activities for this week as we celebrate the anniversary of this great institution. Queen's College has produced great students who have contributed significantly to the development of Guyana and the global community. Wherever you go, you will find a Queen's College student serving with distinction. And this is not contemporary history. this is what has been going on for the past 180 years. Let me concede that I personally have not done enough. In fact, I have done very little, and I'm not proud of it, in terms of contributing to that school after I would have left. And as I said this morning, going forward, I plan to change that. So the activities are continuing, and I wish them all the best. The students who are currently in the school have a great tradition and a great legacy to emulate, but no doubt, like every previous generation of students, they will acquit themselves with distinction and will carry that torch of excellence that has been carried by generations of students over the past 180 years. So I thought I'll begin the program with those important sentiments, because I consider Queen's College to be one of the most fundamental factors in the shaping of my personal life and character. So we have to move on. So the Calvin Brutus matter has made the news. Assistant Commissioner Calvin Brutus has been the subject of investigations for the past several months. The government made it clear that it will not interfere with the investigations. A separate component of the Guyana Police Force that enjoys some degree of functional autonomy was invested with the authority to carry out those investigations as they relate to a number of financial crimes and impropriety. So the Special Organized Crime Unit, as is its mandate, was properly assigned to conduct that investigation. Many criticisms were leveled at the time from various quarters, contending that an independent and a professional investigation would not be done by the Guyana Police Force, in particular the Special Organized Crime Unit. The contention was that the police cannot investigate themselves, that the police themselves at Soku have bones in their closets, and that a professional investigation would not be done. Mr. Brutus chose to embark on a particular course of action of taking the police commissioner to court, taking the Attorney General to court, taking the Ministry of Home Affairs to court, taking the Police Service Commission to court, and taking the Special Organized Crime Unit to court. So he chose a confrontational path long before the investigations came to an end. Of course, there were certain press outfits that were peddling a particular line. The investigation continued quietly, but as a result of these filings by Mr. Brutus, even while the investigations were ongoing, certain disclosures necessarily had to be made in the court proceedings initiated by Brutus. In fact, it is Brutus himself, through his various affidavits and exhibits, who began to disseminate in the court system, and by extension the public domain, crucial information that were hitherto not publicly known. It is Mr. Brutus, through his affidavits and exhibits, who filed and disclosed to the public a large volume of information that the public was unaware of. Naturally, the respondents who were sued had to respond, and in kind. And a lot of information again got into the court system and by extension the public domain, because once you file a document in the court, it becomes a public document. So eventually a lot of information reached the public domain. And you know by now that several accounts, bank accounts, held in the name of Mr. Brutus, businesses owned by Brutus, and companies owned by Brutus, and Mr. Brutus's wife, were frozen under the Anti-Money Laundering, Countering the Financing of Terrorism Act. These accounts contain large sums of money. Various attempts were made by Mr. Brutus through his lawyers to have those accounts unfrozen. Those attempts abysmally failed after legal arguments were presented. One account of Mr. Brutus remains unfrozen, and that is the account into which his salaries are paid. Strangely, that account, up to quite recently, based upon the court proceedings, had dozens of millions of dollars. When one examined those accounts, it would appear that years of salaries were not withdrawn from that account. That account remains accessible to Mr. Brutus. So his entreaties to the court to claim that the state has acted unreasonably and unlawfully in freezing his account and thereby depriving him and his family of a livelihood and a source of income was completely misplaced when it was revealed to the court that that particular account was not frozen, and for good reason. And that account had millions of dollars in it, untouched, until those monies were withdrawn while the cases were ongoing in the court. You also know that an application was made by Mr. Brutus and his wife to leave the jurisdiction. That application was vehemently opposed by the Attorney General and SOCU and the Commissioner of Police. And arguments again were heard by the court, and the court dismissed the application on the ground that there are some 240 odd criminal charges that are likely to be instituted based upon the investigations concluded. The files are with the Director of Public Prosecutions, and as far as I am aware, the charges are going to be instituted based upon the advice of the DPP very shortly. So that's the state of play where, as Brutus is concerned, obviously, when the charges are instituted, steps will have to be taken to by the relevant agency and in compliance with the relevant legal processes to remove Mr. Brutus from office, but that will happen soon. But the point I wish to make is that you had sections of the media and, of course, the opposition who were contending that nothing will come out of this. Now they have seen the gravity of the investigations and the number of charges and the volume of monies that are implicated, and that the government, whom they were accusing of attempting to cover up the matter, did no such thing. They still are critical of the government. I don't know what else they expect. What else they want from the government. The Vice President has spoken exhaustively on this matter, and so has the President. Mr. Brutus will go down in history as perhaps the highest rank officer of the Guyana Police Force to be implicated in this volume of fraud. I believe that he will go down in the Caribbean as an officer of such rank to go down, to be implicated, rather, in this level of criminality. So I'll move on. Many persons have been asking me to respond to this man, Rickford Burke, who apparently spends an inordinate amount of time on me in the social media, and of course on the government of Guyana and several other leading members of the government. I had cause to make public two letters that I wrote on behalf of the government of Guyana to the Attorney General of the United States and to the U.S. State Department in respect of Burke. Those letters were written because Burke, as he regularly does, makes all manner of wild, baseless allegations against the government. I don't think anybody any sensible person takes Burke seriously. You can't be sensible and take Burke seriously. If you listen to any 1 minute of what he says, you see somebody who requires professional intervention of a mental and psychological type. So I don't look at Burke, and I don't think sensible people do. But he keeps writing these things, and the U.S. State Department raised it with one of our officials at the embassy. And we responded. I see the Kool-Aid gang on the social media and Burke himself contending that Guyana government is accused of some transnational repression and was summoned to the State Department. Nothing of that sort. We have made several complaints about Burke in the past to the US government and various agencies. And we made another complaint, as we are entitled to do. And on this occasion, we explained why Burke is before the courts of Guyana, and that it has nothing to do with the government having any type of relationship with Burke. Is that Burke was engaged, or perhaps still engaged, in an extortion scheme, and he's being charged by the law enforcement agencies and being prosecuted by the judicial authorities of this land. And we made that clear to the State Department. But of course, the Kool-Aid gang and Burke himself wants to put a different spin on things, but they can go ahead. I have neither the time nor the energy to deal with Rickford Burke. But let me ask, I'm going to put three questions out here quickly. And since he's spending so much time, I'm told, on me, last night apparently he was for 2 hours cussing me on Facebook and so on. Let me ask three questions of Burke, and perhaps those of you who listen to him can go and ask him. One, let him explain why Desmond Hoyt dismissed him as his personal assistant when Mr. Hoyt was opposition leader in the early 90s, and what became of the $19,000 that was in Mr. Hoyt's desk drawer. Not a lot of money, just 19,000 Guyana dollars. Let Burke explain why Mr. Hoyt dismissed him and what happened to the $19,000 that was in Mr. Hoyt's drawer, in his desk drawer. As I said, not a large sum, 19,000 Guyana dollars. That's question number one. Question number two, let him explain why, since in the early 90s, just after Mr. Hoyt dismissed him, why did he leave Guyana and not return? Why businessmen, several of them, in particular in the Parika area, dealing with lumber, why were they looking for him? And why, when he left Guyana during the mid-90s, he never returned? And thirdly, let him explain why his father, as an officer at the Namstel police station, who was resident in the police station, had to expel him, Burke, as a young man, from the precincts of the station. Let him explain what the allegation was in relation to advances made to a male police officer, junior police officer, in that police station. Those three questions will occupy him for the rest of the month. You will hear him cussing me and bellowing like a baboon in heat from now till month end on those three questions. So I will leave that there, and we can continue the program. You would have seen a very disturbing phenomenon developing in our school system, whereby there has been an increase in devious conduct, violent conduct, and perhaps criminal conduct in our school system by students. The report that we have received, the reports that we have received, seem to suggest that there is some view held somewhere that as a result of the Juvenile Justice Act, juveniles cannot be charged for criminal conduct. Let me reject that absolutely as an utter falsehood. Juveniles who come in conflict with the law are answerable under the Juvenile Justice Act. They can be charged, they can be detained, they can be prosecuted, and they can be convicted. What the Juvenile Justice Act does is simply outline a different regime through which juveniles are to be subject when they are charged or accused of criminal conduct. There is no immunity from investigation, charge, and or prosecution and or conviction in respect of juveniles under our legal system. I am told that even the police force, or members of the police force, let me correct that, certain members of the police force are taking the position that they can't investigate, they can't detain, they can't charge, and they can't prosecute delinquent conduct of juveniles in or out of the court system. That is a complete untruth. The police force has received legal advice to this effect repeatedly. So I hope that it is now clarified again that those who violate the law, whether they are juvenile or whether they are adults, are answerable to the criminal justice system of this country. When you are of a particular age, very young, you are considered doli incapax. What that means is that you are incapable of committing a crime. But that's a very young age. That's not juveniles. Juveniles have a definition. Juveniles are subject to the law. That is why we have a specialized piece of legislation called the Juvenile Justice Act. As I said, they are, however, to be subject to a different regime of treatment when they interact with the law enforcement agencies and the legal system. But they do not enjoy immunity or impunity of any kind. So I hope that that is made extremely clear. As you are aware, Parliament, rather the National Assembly that was in recess, is now back in session. And we will soon have sittings of the National Assembly at which some very important pieces of legislation will be laid, debated, and presumably passed and enacted into law. Among them are the oil spill activities bill, which is undergoing its final review at the chambers of the Attorney General. We have several important pieces of legislation from different sectors. We have from the Ministry of Culture, Youth and Sports will come the horse racing bill, which my colleague Minister Ramsden will speak about. We have a series of children bills that will come from our Ministry of Social Security, and my colleague Minister Vindhya Prasad will speak on them, no doubt. We have amendments to the Financial Institutions Act that the Minister of Finance will speak about, and there are many coming from the legal sector. Among those, for example, is a simple amendment to the Wills Act. In this amendment, first of all, you know what a will is. A will is that testamentary document that is executed by a testator, that's the person who makes the will, to direct how his property or her property, monies and other assets and liabilities are to be addressed after death. That document is called a will, or the last will and testament, if one wants to be proficient and correct. That document carries certain formalities regarding its execution. And it's one of those documents that there must be strict compliance with the procedures and the formalities. If not, the document will be invalid. One of those formalities include that the testator, the maker of the will, must sign that will in the presence of two witnesses who must themselves sign the will in the presence of each other. So you must have the testator, the maker of the will, signing, and two witnesses who must sign, who must witness the testator sign and then sign in the presence of each other. Now, when that will is taken to be probated, the law then requires a witness, an affidavit rather, from one of those witnesses. So when you go to probate the will, you are required to produce to the probate court an affidavit from one of those witnesses to say that he or she is the witness who signed that will, and that they were present when the other witness signed the will, and they both signed the will in the presence of the testator and in the presence of themselves, and the testator signed in their presence. That document must be produced at the time when the application for probate is made. Unfortunately, because a will is probated years after its execution, those witnesses are difficult to find. So the probate of the will is held up for years, and applications have to be made to the court for these witnesses to come forward, or one of the witnesses to come forward. An advertisement usually has to be placed in the newspapers inviting one of these witnesses to come forward. It takes a lot of time, it takes a lot of money, and the entire process is slowed down. What this amendment seeks to do is simply require that when the witness witnesses the will, he or she does the affidavit at the same time. And that affidavit is then attached to the will as part of the will. So when the time for probate comes, one does not have to go to look for that one witness, because you already have the affidavit, which was sworn at the same time when the will was executed. So you take both and you probate it. Now that's a simple amendment, but it will save thousands, if not hundreds of thousands of dollars in legal expenses. It will bring great speed to the probating of a will. It will free up assets. Remember, when a will is not probated, the estate of the deceased persons, all the assets of the deceased persons are held in abeyance until that probate process is completed. Many times you have a dispute. Nobody could touch the properties until the will is probated. And the properties deteriorate, and you have fight, and you have all kinds of things happening. This amendment, as simple as it is, will eradicate many of those eventualities and allow, with great expediency, for the will to be probated. These are the simple amendments in the law that can have such an important impact on the lives of our people. And this is the type of social reform, social law reform, that our government engages in. So we are not only passing the big legislation like the Oil Spill Bill and the Petroleum Activities Act and the Natural Resource Funds Act. Those are massive legislation. We are also dealing with law reform that affects the ordinary litigant and the ordinary citizens in order to make their lives a little simpler. Similarly, we will pass another amendment to the Deceased Persons Administration of Estates Act. Recall 2 years ago, we passed an amendment to permit persons to go to a bank upon the death of the deceased and be able to get from that person's bank account up to $750,000 so that the funeral expenses can be paid for example. Before that amendment, you could only have gotten $1,000 out of that account. Or you had to go to the court and get letters of administration, and then the bank will permit you to withdraw monies from that account. Letters of administration, you have to get money, you have to retain a lawyer, and it takes months, if not years, Sometimes the deceased doesn't have money, the family doesn't have money to bury the dead and to do the funeral. But you have money in the bank account of the deceased, but you can't access it because the law only allows you to take $1,000 out at the time. $1,000 makes no difference. What we did, we raised that threshold to $750,000. As it turned out, that was a welcomed amendment, and then we realized, based upon feedback that we got, that why confine it to the bank? Many persons die and they leave money in a credit union, and the amendment did not apply to credit union. They die and they leave money in some co-op society. They die and they leave monies at their workplace. They may be entitled to a gratuity, or they may have worked for more than half of their salaries for that month. Or they may have contributed to some contributory scheme. And upon death, they are entitled to some endowment. So we now have amended that again to expand the categories of places to which a widow or a widower can go, or a child can go to withdraw monies wherever the deceased may have had those monies deposited, up to $750,000, without the need for letters of administration. Another simple amendment that will have massive positive impacts on the lives of ordinary people. I give you those two examples to show you law reform with a social conscience. And every day I encourage lawyers, I encourage the judiciary when possible, I encourage members of the public to tell me problems that they have in the legal system. Little problems, big problems that we can fix with simple interventions of the type to which I am referring, so that we can make people's lives easier. And that's the type of governance that we espouse in this administration. Many times people accuse us of only looking at infrastructure, and looking at roads, and looking at bridges. We have to look at those things. Those things are crucial for the development of any country. But that's not our obsession. We also look at these small changes that will impact the lives of people, like the Family Violence Act that we enacted quite recently, the change to the Matrimonial Causes Act that allows now, for the first time in the history of our country, no-fault divorce. These are social intervention in law reform to which you can't put a monetary value, but which will have such a positive and massive impact upon the lives of people that it would be immeasurable. So I need to spend some time to discuss our legislative agenda. Sometimes I don't spend that time, so people don't understand the philosophy behind these things. I have read many of your comments in relation to landlord and tenants. And that is one area that will soon be reviewed. We are reviewing the Rice Farmers Security of Tenure Act because there are problems in that act. It has served the rice farmers well, it has served the landlords well, but it's a 1959 legislation. And the realities of the rice industry and the realities of life generally in Guyana have changed dramatically from 1959 to now. So an act that regulated an industry in 1959 can't regulate the industry now. And these are simple adjustments that will affect the lives of thousands of families across this land, in particular, working class families. One of the bills that we'll be taking to the Parliament is the Criminal Justice Alternative Sentencing Bill. While you have laws that once they are violated, you must have strong penalties and put people away for a long time who commit these offenses, there are other offenses that carry jail sentences now that really should not carry jail sentences. The possession of small quantities of marijuana is one. I spoke about that at length. But there are many others on our statute books that carry custodial sentences but really should not. Because 50 years ago, society felt that those wrongs should be punishable by custodial sentences. Society has evolved. There have been social changes, and right across the globe, certain category of offenses are visited with lesser penalties. This bill rather, puts together all those types of offenses and then puts together a whole repertoire of alternative sentences that a magistrate or a judge will have at their disposal when they feel that custodial sentence should not be imposed. Right now, these penalties are scattered all across the law books. Well, in this bill, the Criminal Justice Alternative Sentencing Bill, we have consolidated all these non-custodial sentences, like community service, therapy, counseling, and a whole host. I'll speak more about it, obviously, in due course. So this is another important social reform type legislation that will be going to our Parliament. Another important piece of legislation that will be going to the Parliament during this session is the Trustees Act. A lot of people in Guyana do not know that we don't have a Trustees Act or a law governing trust, the creation of trusts. In many countries, you have this thing called trust, where a person can establish a trust for the benefit of their children or for the benefit of a set or class of persons, even after the person would have died, to look after their educational pursuits and to look after many other endeavors, future endeavors in life. We don't have that mechanism in Guyana. We have an 1893 small trust legislation from England. 1893, over 100 and how many years old? That can't operate in Guyana today. So a trust act, a trust bill rather, will soon be laid in the National Assembly. We have another important piece of legislation that is coming, and which comes as a result of a recommendation from the Caribbean Court of Justice. It's a judge alone trial bill. Many countries in the Caribbean, most countries in the Caribbean, have already moved in this direction. England has already moved in this direction a long time ago. This legislation will allow offenses or certain offenses that are now triable by a judge and jury to be tried by a judge alone. And as I said, the CCJ is advocating this. Why? Because while trial by jury is important and has served society well, there are certain cases that are suitable for a judge to try alone because of various factors. The technical nature of the matter at hand, the fact that for whatever reason it is believed that a jury trial will not deliver justice in a particular case, and many other factors. And as I said, most countries in the Caribbean have already moved in this direction. The CCJ has called upon Guyana to move in this direction as well. And we have a bill that is currently the subject of consultation with the legal profession as well as the judiciary, because their inputs are crucial. And the other matter that I want to speak about in terms of reforms, crucial reforms, is that we have now completed or about to complete sentencing guidelines. Sentencing guidelines that would inform judges and magistrates on what type of sentences to promulgate for different categories of offenses. We have had the unfortunate situation of inconsistent sentences or sentences that lack uniformity, and the principles apparently are not clear on how a particular court arrives at a particular sentence. Because one man gets charged with robbery in one court, he gets a year. Another man gets charged with robbery in similar circumstances in another court, and he gets 7 years. We need uniformity and consistency in sentences. And all over the world, sentencing guidelines have been promulgated. And these guidelines are obviously going to be made public. So you can read them as well. And you can understand why a judge would give X number of years or X number of months. Or you will be able not to understand why, because you have the guidelines and you see clearly is either the judge is following the guideline or is not following the guideline. So it's also an issue of accountability from the judiciary or on the part of the judiciary. That document is with the judiciary and should come back to the AG chambers very shortly for promulgation, for final touches and then promulgation. It's going to be a judicial document because sentencing is a matter for the judiciary. But it's an executive-driven initiative because we feel that sentencing guidelines are important for us to understand the functioning of our judicial system. The last point I want to speak to of a legal nature is that the elections fraud cases are to be heard again on the 31st of October. You know, and the public is well aware, that after 4 years, these cases have not moved in any significant manner. The last set of adjournments of these cases border on scandal. The public has been outraged at the reasons proffered for these adjournments. As I said, they border on scandal. We simply can't continue in this manner. The cases are coming up again on the 31st. It is hoped that on the 31st, the prosecutors and the defense will be informed definitively on the direction that the cases will go. If it is that the magistrate is unable for health or other reasons to do the cases, we ought not to hear that on the 31st without hearing more. We need to hear that, if that is the position, and a firm direction settled in terms of how the cases will proceed, with time being of the essence, so that the early hearing and determination of those cases can be anticipated. The public deserves no less. The judiciary is a public institution that must be held accountable for the conduct of its business. In the same way that the judiciary holds you accountable for your conduct when you appear before them, the same way that they hold the government accountable, the same way that they hold the parliament accountable for passing laws that are intra vires the Constitution, the same way they must be held accountable for the discharge of their functions. Under modern democracies, there is no sacred cow. And this matter, perhaps more than any other in recent times, does not put the judiciary in a good light. I have exceeded the time allotted to me for this program, and I want to thank you very much for spending the past hour with me. I think that we have covered great breadth and length in our discussions. We have covered a number of important issues, and I want to invite you to join me next week as we continue our discourse.